that this proviso could have taken care of it. Why do you specifically say under clause 3 that these are to be Muslim members, and take the others without any indication? Because there is a proviso to benefits.
So there is a choice. Sometimes, at times, suppose in the members of legislative assembly, you do not have a Muslim member, then there is a choice. That's why.
It could be on two options.
Yes, it would be one that it must be from among the Muslims.
Non-Muslims, it could be more than two.
I don't want to.
They're not the way.
Therefore, I wanted your lordships to see our response to the GPC, government's ministry's response.
Because we'll have to go by the wording of your section.
I'm saying,
can't argue contrary to the language of the section.
But I am saying,
having the right takes of Muslim members only under clause C.
But section says the same thing.
Only under clause C you speak of Muslim members.
There is a flexibility.
So the rest of the members could be non-Muslim.
No, but not more than two. But proviso will have to be read with 1 and 2, A and B.
The proviso does not say that only 2 members shall be. Further than 2 of the total members.
That is what
the argument is militating against the combined reading of both these.
It is not. But this was the confusion before GPC. Therefore, kindly now, not for my satisfaction, have a look at what we say before GPC.
Your GPC merits into the section.
I find an affidavit. That's how it is understood. Another thing. I must tell you, lordship. All council, this council, all Waqf boards, till they complete their tenure, they will complete the tenure. Whenever the new body is to be formed, this will come into effect.
The existing board and the council.
Obviously, nobody goes.
What is the term of the council as a
Different.
There will be different council for different
Boards.
Boards will be different. Boards will be different because boards are, any Waqf board is there must be other Waqf board.
Please, this is a matter being argued by lawyers.
As far as council is concerned, when is the term of the council coming?
I can take instruction. Somebody is shouting there is no council. I can't answer that. Because there is no council in existence today. For 2.5 years, there is no council.
Okay, now, according to you, therefore, the ex officio and only 2 other members can be non-Muslim.
Which can be
and other members will be always be Muslims.
It only says that if there was a trust which has been defined.
Okay, that will have its own consequences.
I will answer your lordship why that decree etc. has come. According to me, doesn't seem to be for any particular to nullify any judgment. It's an empowering provision that if I am a Muslim, I don't have to.
But then there's a difficulty in that. I see where the public trusts have been already declared to be a Waqf, say even 100 years back, 100 years back. Now suddenly, 1 minute please, now suddenly you turn around and say that these are being taken away from the Waqf board.
No.
And then now given to the
allow me to say in the example. Please allow me, in the only please.
1 minute, that's the assumption. 1 minute please, because that may not be.
That's not correct, that's not correct. That's not correct. What it means is this, even if it is a Waqf, if I want to convert it into a trust and come out of this trust Waqf Act, it is open for me. It's an enabling condition. If today I am a Muslim, I want to do something for charity, I don't have to make Waqf. I can make a public trust or any other trust. It's recognized by 5 days in a Waqf Act.
Can't rewrite the past, say even 100 years back or 200 years back.
Nobody is rewriting the past. Kindly have a look at it once again. It's not rewriting the past, it's an enabling provision. Provided further that nothing in this act shall, notwithstanding any judgment, decree or order by whatever name board, apply to a trust established before or after the commencement of this act.
Before also. Not, I can understand after commencement, but not before.
If it is a trust already before commencement, it will not apply to which is a trust already when in 2025. So trust would not become a Waqf because it is by Muslim for some Muslim religious pious charities. But kindly have a look at kindly read once again, provided further that nothing in this act shall apply to a trust by whatever name called established before or after. So trust has to be established before or after commencement of this act or statutorily regulated by any statutory provision pertaining to public charities by a Muslim or similar for purpose similar to Waqf. Suppose in 2022 some trust is created by a Muslim under the Public Trusts Act, nothing would prevent, this act will not come into force.
For this Public Trust Act is something which is state-wise. It's never been, we don't have all India Public Trust.
Indian trust.
There have been instances where people claim trust, they intend to, give it really to the God, Allah. And therefore, those have been always treated as one. Even at
I can show a 5 judgment. citation. Lord, I can give you 5 judgment of Hyderabad Nizam.
That should be the very simple answer, if I may.
No, please, let us continue as lawyers. Let's continue.
And issue notice, file a reply.
I'll file a reply. I must, only a minute. Mr. Jain, Mr. Jain, if you don't mind, sir. Sir, there is an answer to your lordship's question in the judgment of 5 judgments, 63-1 SCR 469. There can be a trust by a Muslim for the same purposes which are providing for Waqf. This issue of this is Nizam, Hyderabad Nizam.
So, but then you undo that.
We are not undoing. If somebody has created a trust, it will remain a trust. Merely because it is for Muslim charity, it would not be governed by Waqf. So that's it says.
But yeah, it's a very simple answer, if I may assist, but notwithstanding the judgment is one thing.
Pardon?
Lordship from earlier opinion that the challenge to the earlier of she the delegated parties clear. And the
A very simple answer. My lord in Sheikh Yusufbhai Chawla said that the purpose and the intent is the test. Now this is saying that notwithstanding the judgment, the establishment is the test. So that's what the difference is. Those judgments cited are said that purpose is
are the petitions challenging 95 acts. These are petitions.
Order in the fourth page, not 2025. Particulars.
22nd March 23 order, where 120 petitions are pending.
You have withdrawn that petition?
No, it's finished.
They're still pending 140 the challenge in those petition.
95 Act. 1995 Act.
That's a.
they are pending. 30 years later they are pending.
So where the Waqf by user has been challenged in those proceedings.
The Waqf by user has been challenged.
Yes,
And 30 years later they are pending. That's a good one.
I did not answer that because I have no difficulty in finding the structures. Because I didn't want to show that we are hesitant in answering pending your questions.
There are still challenges there which will survive.
Because they have done all the 3 options before us. First is we decide this challenge. Second is we delegate you to a one common high court.
And second should come with a 1 minute protection in the meantime.
1 minute. Just 1 minute.
Lordship will have to protect.
That's okay. In part A and part B of section.
Lord, can I say?
1 minute. Part 3 is that we call those petitions also over here and decide this.
It is as decided here. Pending for 30 years.
Okay, we'll not be able to.
Can I suggest
Question, sorry, just a moment.
Can I suggest
Question that in view of this amendment act, which is very sweeping,
Probably many of them have No. So you may have a point of view.
Can I
It will not become infrastructure there, but the issue is when the constitutional reality is being challenged. Then, depending upon our answer over here, they cannot be back out.
Can I submit? I have only a minute, sir. Please.
Lordship is very clear. This will be a very.
Now, your lordships may issue notice. I'll file a reply within 2 weeks. Kindly take it up on a day-to-day and finally dispose it up. I have nothing but therefore I'm.
What's your three situation till you?
Lord, I didn't want to support that position, Lord, because that way I'm hesitant in sustaining this amendment before your Lord.
I support your solicitor.
I support him. I want to call those matters.
Otherwise, experience of the 95 Act
situation where you and those risks are also not considered.
There are several judgments, etc. We will assist in
There's another solution.
yes, within itself, Lords.
There's another. So I'm appearing in a petition where the old act is under challenge, which we have filed here. So your lordship will hear
Within
dimensions
itself,
of the
Lords.
matter and
My
lordship will decide
exception,
the
we'll
matter.
just practice it.
There's a old act, a challenge pending in this court. Yes.
Everything should be here.
Item number?
Within itself, Lords.
No, this is 99.
I think there is a fresh petition filed.
Yes, it's a fresh petition filed.
95 Act with amendments.
Because the reason is the 1995 Act has not been taken away for the past in respect of certain matters. So both sides of the picture are before the court. Your lordship may hear the whole matter finally, because it's a matter of moment. Your lordship may hear the matter finally and decide it one way or the other. So there's no need for calling the High Court petitions.
So my purpose. Ready for the additional sign. Waiting for that. Seems something good. It's a secret only. Say it out.
today the maximum number of matters are pending. 140 matters.
Nothing will happen there.
And there is no other matters pending in any other argument.
Your Lordship will recall the island rule matter, which was very, very pressing. Your Lordship, the NGAC matters, Your Lordship transferred all of them to this court. You can't get a listing of this, right? NGAC matters, Your Lordship transferred to this court. And then I could have been to the bar of 30 minutes. Okay. Most capital, as Your Lordship just writes is one sentence. Now, four pernicious provisions status. What is the status? 3 bracket R. 3 capitals. I want to 9 and 14.
You have addressed us. We pass an order.
9 and 14.
Which we have heard you on different aspects. Order we are passing, or whichever interim order we are passing, will not will balance out the.
Lord, can I get hearing for interim order? We should be heard on interim order.
1 minute. 1 minute. The interim order which we are passing is on two counts. Let me put it. It is not party. It's on two counts. 1. Whatever properties have been declared to be
Registered.
But no.
How would
Just
you?
1 minute.
I declare.
1 minute, Mr. Don't put words into my mouth. Hear my words first.
No, I'm sorry. I'm sorry.
Declared by court.
1 minute. Whichever properties have been declared by the court to be Waqf or held to be Waqf, yes. 1 minute please, will not be denotified as Waqf, they will not be treated as non-work properties, whether they are by work by user, work by declaration,
I'm out of.
or otherwise.
I'm out. Please, you will.
No, declared by court or otherwise also. Number 2, it is being permitted. Just 1 minute. It's not. We have concerned. The council and the boards is concerned, ex-officio members can be appointed regardless of the.
Kindly will not hear us on interim.
1 minute. 1 minute.
But we have not given 1 minute.
Please, we hear you in court. We can hear it tomorrow itself.
Kindly will not have a look at it.
1 minute. I thought it balances out. It balances out completely your interest also.
So far as words are concerned,
1 minute. Tenure is 1 minute. Just listen to the second. As far as the board and the council are concerned, as far as ex-officio members is concerned, there is no difficulty regardless of the faith, they can be appointed. But the other members should be members of the Muslim Muslim.
only a minute. Allow me to answer. Allow me.
Yes.
The losses have decided I have nothing.
No.
As far as asking you, far as boards are concerned, their tenure is yet to expire and
Why we weren't there?
because of the order. Because of the order, without am I assisting the lordships with the judgments? In case of Tilkaya judgment.
Okay, when new boards are to be appointed, then in those cases, don't right?
No, then we'll come before your lordships. If we are not even
Okay,
kindly
before you appoint the board, then you come before us.
No, kindly a minute. Only a minute. Not kindly a minute.
No, we cannot have this. We are asking them, they have
But the difficulty
But
all our public interest litigants, there is not a single board before your lordships, single affected works before your lordships, that I am going to be affected or demolished or removed or something.
Tushar Mehta, so Tushar Mehta, one hand you are saying all boards are already in place. Yes, they have terms which will come to an end after a particular time.
Yes.
Correct? Okay, we can record your statement that before you appoint any new member of the board, you take up you can move an
The lordships may say,
I means it.
the lordships may say, please act actually says, because I have judgments to show, in Tilkaya, the lordships are aware, 5 judge or 7 judgment. In Tamil Nadu, only a minute, kindly allow me to show. Please examine the section 48 said elected member Tamil Nadu government in the case of Archaks, that is Pujari. This honorable court says that Pujari's function is a secular function and government can appoint Pujari.
But we are not on secular functions.
But I am on secular function. Yes, not us. It's an administration of property.
Very normal.
It's an administration of property issue.
Our expectation, they are done away with the legacy from the Muslim convention.
Being works by non-Muslim can't be secular.
CEO must be taken.
The CEO has to be Muslim.
Lordship may hear us tomorrow or
We can hear you for 5 minutes. As ex-party state is concerned, it's always an element of discretion. You are not entitled to be heard as well as the issue of notice is concerned. You are only entitled to be heard as well as.
This is a matter which is something different from the ordinary litigation. This is a matter.
Therefore, we have spent so much time.
No, I appreciate it. I'm not critical.
But then it's also a matter. It's a matter of we are all concerned about it. Let's find a solution.
You correct, First, we'll find I'm there.
Your lordships may, but why sometime or tomorrow. We would like to address your lordships on the internet. But your lordships have recently in the election commission laid down the law on when the statute can be stayed. Directly or indirectly.
No, we are aware of that. We have all of us know those aspects. We are also concerned. Normally, the two courts which apply. First 2 days, normally when the legislation is passed in order, passed legislation, courts move on. it's like they order and take issues, and they exceptions to it. There's an exception which we feel in this case is in case there's already a work by user, if it is to be denotified or anything, it will have its huge consequences. Once we update, we'll expedite the hearing. Maybe it takes 6 months, maybe it takes 7 months, but that's fine. But number two, as far as the members of the council and the board is concerned, you yourself saying they have tenure. Council is today not in existence, but the board which are already in existence have a tenure. If they have a tenure,
or alternatively, my statement on proviso be recorded. Then it would be maximum 2. So that also not tell you one of the balancing act. It's a balancing act. So you can't have the difficulty will be you are appealing for the central government.
as far as the boards are concerned, they have to be constituted by the state government.
I'm interpreting.
But how will you find the state government? You have to pass it what?
I'm interpreting a central law.
We'll record your statement and then pass it.
Then we have time.
Can we hear you for half an hour and then finish it off today? Or keep it for
Tomorrow.
But extremely grateful to the Lordship. Here's the
Kindly have it tomorrow.
not for what this.
question. Not a week. Everybody's on the other side. We can't hear everybody. You're not going to hear everybody.
That's why we want like that, brother.
No, we have something to assess your knowledge.
They're all interveners.
What else is there? Mr.
No, kindly allow us. Kindly allow us. It's not
Okay, well, actually, I thought we had made the consensus between people to say.
No. It cannot be. It cannot.
Okay. Mumbai user is there from 1940s.
No, can I,
Right on. Okay, I'm just creating a tentative order.
no, your lordship may have it tomorrow. No, actually, we must have on it.
Your Lordship, that this will continue like that.
It's a matter of
I thought Mr. Lehner, we thought we had virtually reached the consensus as far as you were concerned. I thought the others know what was objective.
I would not.
So we virtually were that. We virtually, what we said, they will just reiterate that little more what we spoke.
We have something to do. We have some grateful to the Lordship continue the hearing tomorrow. You are grateful. We can know that this will just continue in this fashion. The Lordship will continue essential points are before your Lordship, but otherwise we don't have fun.
It's simple. We have maybe heard Mr. Delaney. That's a fact also. We haven't heard it.
Mr. Rajit Kumar is there, Mr.
I know. I cannot count the numbers here and there.
We are not balanced.
We are not in wrong number game.
But we have to contribute.
Okay, come to what 2 o'clock.
Okay, good.
Only 3 councils. Decide amongst.
Kindly limit it to half an hour.
Apart from the
Kindly limit it to half an hour. Then go on.
apart from the half an hour and 10 minutes to us for rejoinder. Half an hour and 10 minutes.
Okay.
Keep your guys.
Mr. Sindhu can't fix the time limit already.
No, he only 10 minutes. I'm writing it down to 10 minutes.
I'm saying 10 minutes only.
It's our time limit.
Yes, we are saying
It's our time limit. That he may not.
And I hope one thing was really disturbing, the violence which is taking place.
Yes, that's your time. I agree.
Once the matter is before court,
Yes, nothing should happen.
rights are concerned, we'll determine and decide.
This is
That's why it's important for your Lordship to be
And why is it not a phenomenon?
Absolutely.
That you can pressurize the system by violating,
I don't know who's pressurizing.
Unacceptable.
Wonder who's pressurizing.
Unacceptable. Must stop.
Must stop.
And it's must find, let's also put a, both of us, we just discussed, there's certain positive points also. Nobody wants to highlight that, please highlight both.
No, we would have. I'm yet to highlight. I only responded.
Half an hour tomorrow.
The positive
We will have to highlight the discussion.
Thank you.
Obliged.
Within itself, my essential religious practice and must be reasonable and proportionate. So that's by and large the broad submission under which we have to examine the provisions of this act for us. Well, let me straight away, brothers, kindly come to section PR of the Bare Act of the Unified Waqf Management Empowerment. We have printed Bare Acts, brothers. Can we just hand them over to your Lordship?
comparative chart.
I would just have the Bare Act first. That's right.
Just for content, Parliament also.
Allow me to give the Bare
This
Act.
is the act with the amendment.
Yes.
Oh, can we see on page 44, which is now deleted?
I have it.
I see it. The amendment. Yes.
जो टर्म्स वगैरह नहीं होता ये तो बेसिकली अगर चेक
Yes, Mr. Sipal.
Let us kindly look at 3R, definition of Waqf. Waqf means,
Yes.
Waqf means the permanent dedication by any permanent dedication showing or demonstrate 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 by set up a Waqf or create a Waqf millets. I'll have to show that I have been practicing Islam for 5 years to the state. Well, why would I? It's my property. Why would I have to do that? If I'm born a Muslim, why would I have to do that? Why should the state be a judge of whether how good a Muslim I am or not? My personal law will apply to me, brothers, immediately. So, brothers, first say according to me, brothers, this, and then, brothers, what is that contrivance involved in it?
Given that we have a title straight, I request you to shut up.
All right. Yeah, brothers, this is
Also cut down the time because this is a initial stage hearing. I request everyone not to repeat whatever has been said and should not be repeated.
correct. But now I tell you, Lordship, what section I'm challenging. I'm challenging that within itself, brothers, my essential religious practice, and I must within itself, brothers, my essential religious practice, and I must be reasonable and proportionate. So that's by and large, brothers, the broad submission under which we have to examine the provisions of this act, brothers. But let me straight away, brothers, kindly come to section PR of the Bare Act of the Unified Waqf Management Empowerment. We have printed Bare Acts, brothers. Can we just hand them over to your lordship? Comparative chart. I just have the Bare Act first. And present them. That's right. Just for convenience. But allow me to give the Bare Act. This is the Act with the amendment. Yes. Sir, I have it here. But I see everything with the amendment. Yes.
Yes, Mr. Secretary.
Let us kindly look at 3R, the definition of Waqf. Waqf means, your lordship has that?
Yes.
Waqf means the permanent dedication by any person showing or demonstrating. Does you also don't have the Bare Act?
Yes, we've got the data.
So 3R, Waqf means the permanent dedication by any person showing or demonstrating that he is practicing Islam for the last 5 years. Of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property, for any purpose recognized by the Muslim law as pious, religious, or charitable, and includes such and such and such and such. So, brother, therefore, if I want to set up a Waqf or create a Waqf, brothers, I have to show that I have been practicing Islam for 5 years to the state. Why would I, it's my property, why would I have to do that? If I'm born a Muslim, brothers, why would I have to do that? Why should the state be a judge of whether how good a Muslim I am or not? My personal law will apply to me, brothers, immediately. So, brothers, first say according to me, brothers, this, and then, brothers, what is that contrivance involved in it?
Given that we have a title straight, I request you to shut up.
All right. Yeah, brothers, this is
Also cut down the time because this is a initial stage hearing. I request everyone not to repeat whatever has been said and should not be repeated.
correct. But now I tell you, lordship, what section I'm challenging. I'm challenging this, brothers, 3R.
Yes.
Then I'm challenging, brothers, this proviso to 3. Proviso to 3. Provided that the existing Waqf by user properties registered on or before the commencement of the Waqf Amendment Act as Waqf by user will remain as Waqf properties, except that the property wholly or in part is in dispute or is a government property. This is the proviso. Waqf means, after Waqf means, page 6 of the compilation. But they have, as your lordship knows, brothers, deleted Waqf by user.
Yes.
For the past, brothers, they have maintained it.
Yes, right.
For the future, they have brothers. So that's another challenge. That who are you to say that I cannot create a Waqf by user? That is my essential faith and practice. So, brothers, that's the second challenge. And this, every encroacher, brothers, will have to be, it will be decided. Who will decide that? The dispute mechanism, brothers. Now, kindly come, brothers, to section 3C. First 3A, brothers. 3A, 3 capital A, subsection 2. I'll just read it, brothers, and tell your lordships what the challenge is. Creation of a Waqf, halal or adat, shall result in denial of inheritance, and shall not denial of inheritance rights of heirs, including women heirs, of the Waqf or any other rights of persons with lawful claims. Well, who is the state to decide that? Under what lawful claim are you talking about? Well, who is the state to tell us as to how the inheritance is going to happen? In my religion.
Even under the Hindu Succession Act, the state has enacted the law, hence the service succession to take.
In Islam, brother, that's not the case, brother.
Are you saying that?
That's interference at 26.
Yes, question for you answer. Parliament cannot enact any law. Parliament has enacted law with regard to Muslims also. May not be in this to the same extent as case of Hindus, but it has enacted laws. It has enacted laws with regard to.
No, I'm not on that, but it's because of 26. I'm sorry, but I'm on a normal, narrow issue of 26.
26 does not bar the legislature, Parliament as a case may be, to enact laws.
Subject to morality, public health, and public order. This is nothing to do with that.
But that's never made 26 never created either, because 26 is universal. It's secular in the sense because it applies across all communities.
Yes, that's correct.
So, Hindu Succession Act, Hindu Guardianship and Maintenance Act, so many acts have been
I'm not. Please, all right, I'll just move on, but I just tell your lordships why the challenge. Why the challenge? Inheritance in Islam applies after death.
Correct.
They are interfering before that. That's the point. But that's the point, what you I'm just flagging the point so that there's no time. So that's point number 2. Correct. Point number 3 minutes. Kindly see. 3. PC. In page 9 of the book that I've given to you, Lordship. Any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be a Waqf property. Any government property identified or declared. So whereas if they identify or declare, it shall not be Waqf property. Then minutes 2. And I think the whole section is ultra-virus. 2. If any question arises, whether any such
2 of section
3C, 3 capital C. Well, first 3C1. It's much better to look at that. Page 9 of this book. 3C1, may I read?
Yes.
It says any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be Waqf property. So they can make a declaration saying this is not Waqf property. Now see how that is done. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of collector, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law and determine whether such property is a government property or not and submit his report to the state government. Provided that such property shall not be treated as Waqf property till the designated officer submits his report. And there's no time limit there. Quite apart from that, what is that process? Where the government officer will decide in a dispute between the government and the Waqf that this is government property. You therefore have identified an officer who is part of the government, who will be a judge in his own cause. He is an officer of the government. And he gives a declaration. Identifies and gives a declaration. This is again of India, one member of the Bar Council. This is anyway, but collector's process is not a judicial power.
Collector's decision is amenable to the tribunal.
No.
It's not amenable.
No, not that the section says so. Section specifically says, and all means also dispute. Kindly see, all is in dispute, which means they are not sure that this is their property. So nobody can deal with it, Mullah. Till such time as it is decided. So it's no longer be a Waqf. So that's 7A, Mullah. Now kindly, then, subsection 10 of subsection 10 is the no suit, etc. Yeah, no civil court will have jurisdiction, that's right. That's the tribunal.
What is that?
Well, that's subsection 10 of 10. No suit, of this section, no suit, appeal, or legal proceeding for the enforcement of any right on behalf of any work which have not been registered in accordance with the provincial instituted or commenced of first.
Limitation period.
Well, that's the other very serious issue. Previously, under the 1995 Act, there is no limitation. I tell you what is fine.
Limitation can be always imposed by the government.
No, I'm on strike.
Before 1995, we had the limitation.
No. Under the 95 Act, there was no limitation. I'll tell you the reason why. Because many of these properties were encroached upon. And therefore, in the context
You can't really say that if you impose a period of limitation, it will be wrong, it will be unconstitutional. Limitation Act has its advantage.
I'm not of that, but I think the point I'm making is somewhat different. And the point is, that at that time, if within 2 years we did not file a suit, I can't file a suit now. Therefore, if the Waqf is created, say, in the 1930s,
There was no limitation period, that means you can always file a suit.
but now it says it has to, after 2 years at least.
If your work property is not registered, then you have to file a suit within 6 months and 6 months plus.
No, but these properties are not registered. These are Waqfs by you, there's many of them. So how will I file a suit?
So we asked them about
So therefore, that's the other
understood. You understood.
That's the other issue with us. Yes, and they will claim adverse possession and encroachers will be legitimized. Encroachers will be legitimized in this process. And let us kindly see now 1A. That's another important page number 51 minutes.
1A or
1A of section 61, penalties. Sorry, that's right. May I read that?
Yes.
It says, if a mutawalli fails to deliver possession of any Waqf property ordered by the board or tribunal, carry out the directions of the collector of the board, do any other act which he is lawfully required to do by or under this act, provide a statement of accounts under 46, upload the details of Waqf, he shall be punishable with imprisonment for a term which may extend to 6 months and also with a fine which shall not be less than 20,000.
That's in case of violation, there's so many acts.
No, just go to jail, Maharaj. 3B, Maharaj, kindly see. 3.3.
Next one is the second.
No, just one other thing. Then kindly see 85.
85.
Yes.
Yes.
No suit or other legal proceeding shall lie in any civil court, revenue court, or any other authority in respect of any dispute, question, or other matter relating to any Waqf, property, or other matter which is required by or under this act to be determined by a tribunal.
This is a new one or
It was there. It was there earlier also. But there was a tribunal. The difference is that the nature of the act has been changed. Originally, everything had to be decided by the tribunal. Here they have introduced 3C, which the tribunal. That's I'm not forfeited my. No, you're not forfeited. You're right. Just one question that I from the questions. The basis of our constitutional act is that what is essential and integral to Islam. That was the basis of our attack. And religion, and particularly charity, is an essential and integral part of Islam. The original test essential was in 54. This other aspects, my Lord, Mr. Sibbal, I adopt that argument, both about the change in the nature of waqfs, the change in the composition and loss of control. Earlier, even the chief executive officer had to be Muslim, no longer. And lastly, my Lord, many of these provisions are arbitrary and contrary to Article 15. That is the summation of our argument. I'm very grateful.
I just want to say this. Once have been covered the same point. Waqf by user deletion is very serious because the statistic is that 4 out of 8 lakhs, 4 lakh out of 8 lakhs perhaps are waqf by user. So by one stroke of pen.
I didn't want to interrupt you with this. There's an issue. You see, when we are in Delhi High Court, we are told Delhi High Court itself is bigger than our flag.
All right.
So Oberoi Hotel is bigger than our flag.
There are petitions which are declared.
Please. We are also told Parliament has flags.
I'm sorry.
We are told Parliament has flags. These are imagery created.
Just one. Don't misunderstand us that we are not saying that all work by users are wrongly registered. But at the same time, there's an issue and concern.
Absolutely yes. But what you are talking about is an individual abuse. You're not throwing the baby out of the bathwater. You are considering a, let's say, legal abolition of the concept. Now let's do an issue right here. Issue number 1. Waqf by user, is it a novel concept created? Is it something new? Your lordships in para 1118, I think it was 113, but it's para 1118 of their judgment, have traced that this is a very old lineage concept. Very old. Number 2 question arises legally. Have you removed the basis of the judgment? Also, Prithvi Cotton is through Madan Mohan Patel. You have to do something to remove the basis. This act says that deletes. No, 2RI is deleted. Just see the old 2RI. 2RI today, your the book is a blank. In the footnote is given the original 2RI. Now that you delete. By deletion, can you remove the basis of the judgment? The judgment was not based on a waqf by user. Again, it's based on an ancient material. So that's point number 2. Point number 3, the practicality. 4 out of 8 lakh waqfs are supposed to be waqf individually. If I go and claim Parliament to be waqf, Lords will not accept it. That I can understand. But you don't say the concept is bad. That's point 1. Point 2 is that there are 2 bodies. One is the collector, and one is this fellow called the designated officer. These 2 are the worst examples of judges in their own cause. Because of a series of provisions, Lords will note that in this book, management has pointed out many of them. If you read them together, they are completely judges in their own cause. Starting with 3IIIDA. Just note that. The collector is defined very, very broadly. Just see that definition. 3IIIDA. Collector is not a mere collector, as the Lordship thinks, fellas. Everybody, land revenue collector, deputy commissioner, or any officer below the rank of deputy collector. Then please add to it those other provisions that say designated officers for other things. Till they decide, this shall not be treated as waqf property.
That's it.
Thirdly, they will decide.
This is already flagged.
Yes. Then the third thing is, the third issue is, therefore there is a subordination. Because those provisions, well, may have given you the chart. Those provisions are very important. Just give me half a second. Sections of the Karnataka Hindu Religious Institutions Act, Dharmika Parishad Act, Religious Endowments Act, EP Charitable Act, and the sections are there.
Okay, that's one.
No, that's one network.
For education state, this is
No, I'm not going to repeat, brother. The problem is also trying to sift through that, I don't have to repeat. There is a reason why we are saying that this word contrivance is intended to make the person visit the officer for lifelong. Apart from the fact that I have to prove I'm an adherent to Islam. Is that not part of it? 5 years. It's a cumulative condition. I've done Islam for 5 years, I go and show my faith to somebody. Thereafter, there is an additional cumulative condition of contrivance. Now, this is a delightfully big word. If you I continue going to the office, and I'll be under your control. For life.
Already argued. So take away answer.
Can I answer the first question? There are 3 reasons why it should not even be considered remotely for going to the High Court. Just 3 reasons very quickly. 1, it has all India ramifications. Your lordships would never say that there should be High Court judgments of multiplicity and diversity.
Except that argument, then law matters where stations are judged.
No matter will come with this. Kindly see. Put my lord's countenance, multiplicity of High Court judgments. Diverse High Court judgments.
He can direct this High Court.
Same thing will happen with your lordship will today. Number 1, this is a
High Court judge.
Let me give you all the 3 reasons. Number 1 is your lordships. There is no absolute bar in 32. There is a discretionary bar. 3 conditions. 3 conditions. The first condition is Article 32. What is more one is Part 3 than Article 26 and Article 25 directly. Secondly, the lordship will have all over the country, or even a lordship consolidates. What will be the point of spending this time and ultimately it has reached the Supreme Court. So therefore, today, this is not that kind of a case where lordship sends us to the High Court. Okay. And there is also an issue that your lordship should lay down the law definitely on this one. I will end my thing. No, I'm only one. Okay. Now, 2 more. 1 minute. Quick consultation. 1 minute. 2 seconds. Because I am saying this, Emmanuel would also meant the same, I'm sure. Some of these pernicious provisions, they come into effect immediately. We are seeking a stay for the reason. Your Lordship is saying 3 judgments, health for millions, then was Jayashri and Rakesh Vaishnav. The only argument is a new act. Lordship doesn't stay the act. The other is staying the act.
We come to that part later.
Only one sentence, when there is a status quo continuing from 1920,
Simply why you argue that
the first act was in 1930.
But I have a slightly different take on things. So I'm in 13.2, the Association for Mediation of Civil Rights. Just give me a moment. Look, I just want to point out one thing which is very, very important. Article 26, apart from 25, Article 26, let's please just see Article 26 for a moment. Mr. Civil, sorry to your Lordship, but I want to just stress one thing. Because I'm deviating a little bit from this essential religious practices or essential religious feature argument. I don't think it's necessary at all, as far as the Waqf Act is concerned, to show that it is a part of the essential religious practice of Islam. PC 26, freedom to manage religious affairs, subject to public order, morality and health. Every religious denomination or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purposes. Please note the distinction drawn by the framers of the Constitution. Religious and charitable purposes. Now, charitable purposes do not have to be to answer the test of essential religious features. There can be charitable purposes which has to do with a person who believes in Islam, but does not have to answer. Now, contrast and to manage its own affairs in matters of religion, etc., etc. Now, in Shirur Mat, your Lordship said there will be certain secular aspects where the state can intervene.
you saying just read D also.
No, so, and D, to administer such property in accordance with law. Yes, law gets
Law can interfere. This accepts that law administration will be in terms of the law.
No, Lordship's right. Preface, no, that's just one thing. Preface with subject to public order, morality and health. Those are the only things. Now, please contrast this with 25. 25 says, another provision. Plus 25 says, subject to public order, morality and health, and to the other provisions of this part. All persons are equally entitled, etc., etc. This is why, Manoj, 14, 19, 21, etc., etc. Other provisions of this part came in, for instance, in Reverend Stanislaus, where your Lordship were considering the Freedom of Religion Act in Orissa and Madhya Pradesh. 26 draws a complete departure from 25. This is now your Lordships have held in Sayadna and reiterated that even while referring Sayadna recently. Your Lordships have held in the Tanka Committee. Your Lordships have held in Sirur Mat. These are all constitution-based judgments. And my lords, in the state of Rajasthan versus Sajanlal, Punjab, etc. Series of judgments. Your Lordships have held that 26 bars state intervention except on provisions, except for public order, morality and health. That's all. Now, therefore, please, minutes. And just one last point. It's a slight repetition. What I'm saying about just one thing on 3C, that's very, very crucial. Because the moment a dispute is raised, it's not like you understood that. It ceases to be a Waqf. I just want to put it in a context. Suppose there's a Waqf by user for 300 years. Let's say it's a graveyard. Let's say it's a mosque. The moment somebody says, no, this is government land, you just have to say it. Then, for the next 50 years, designated officer, tribunal, high court, Supreme Court, it ceases to be a Waqf. So that's the same is very important in that context.
There's a reason in constitutional history why 26B exists, to manage its own affairs in matters of religion. The Lordship is from Amritsar. The Lordship may recollect that the Golden Temple in Amritsar had non-Sikh control. It required a whole Akali movement to regain control of their own Gurdwaras. So that is why the clue is to manage its own affairs. So own means necessarily an exclusion of somebody who is not your own. And that is the principle which has consistently been followed from
I will make one submission. I want to be.
Can I just make a cue for what I have done? I'm mistaken. Is it? I come from Kashmir.
Microphone.
Lord, I come from Kashmir. I'm a Kashmiri Pandit. Correct. There are temples over there. And tomorrow Muslims would say because they're in majority, they're going to manage my temples as it is my temples are gone. Would that be acceptable to the other side? Please juxtapose like this proposition with the acts that have been shown. And I made something right for your Lordship's colleague. No, this I'll make one subject. One more thing. But can I just complete one more thing? Your Lordship was saying whether the decision of the collector. But your Lordship was saying whether the decision of the collector is final. Please see section 40 of the old act.
Yes.
No, my Lord, your seat can help.
Yes.
Your Lord, at the foot of the page, at page 38, these decisions, where there was a dispute with regard to whether a property is, does not Lord Justice Vishwanathan have. Page 38.
It's deleted now.
It is, but it gives a perspective, my Lord. It used to go to the board, and if there was a dispute, it would go to the tribunal further. Okay.
Now it does go.
3C says the collector decides. He's high and mighty.
Go to the tribunal.
That's all I think that's on the side.
Only one submission. Only one submission. Don't you kindly see, my Lord, argument. I will not repeat it. 103. Item number 103. We are appealing for a chief party as well as for a member of parliament, Mr. Raja. But your Lord should kindly see, my Lord, Article 26C. Blood, they want blood, a probation period of 5 years.
Lord, to certify that a person, Lord, is a Muslim. Lord, 3R, if your lordship sees, Lord.
That's been already answered.
Yes. So therefore, Lord, my submission
Without-
against fundamental rights.
That's not fixed. But just in terms of additional sections that we're asking for stay off. Just 2 or 3
You're not arguing, you're not arguing on state, you're not doing that.
Your lordship, may I try?
That's all fixed.
Lord, I appear in item 63.
It's all fixed. Nobody else. Fixed. No one section. That's it. We have to drop button somewhere. Section. We should state nobody has the right. All right.
418 may be read of the building.
Okay.
This one he said, Lord, that the survey has to be done within 1 year's time. Lord, that was introduced, Lord, that was inserted in 2030.
Okay, yes. Yes, please.
But you survey all the states are on record. Does that mean?
Okay, that's all fixed. Yes,
This is an item sheet. Plus item 63, can I?
sorry. No more. No, I haven't put the
But Lord, just give me 1 minute.
not required. We've heard you. We've heard. We don't have brought parameters on which you are. I mean, in fact, the point which you have raised.
Can I just state something in 60 seconds, Lord, if your lordship allows? Because I prepared a short note, but I take it that your lordship doesn't want me to hand that over. I won't hand that. Just 2 points. Firstly, on 3R, there are 3 facets. One is, Manoj, that you change the definition. Everyone has said, Manoj, that the original definition included Waqf by user. Now, Waqf by user has been omitted under the new definition. And Waqf by user, Manoj, is a practice which is essential or fundamental to Islam itself.
We have understood.
And it can be trained.
Mr. Every or repeat.
Yes, we have understood very well. Then point number 2, Manoj. Can I go to the next point? If your lordship allows. Point number 2 is this, Manoj. The expression, Manoj, if your lordship
Yes, sir, people-
not inclined, because I don't want to just stretch it further.
Okay. We are hearing you. It's not difficult.
So point number 2 is the expression used in, my learned friend made the point, I just want to develop it a little more. The expression used is Manoj, practicing Islam for a period of 5 years. Now, if this is an essential religious practice and it is protected by Article 25 to 26, it has the effect of suspending fundamental rights for a period of 5 years. Now, point number 3, just 1 more minute. Just 1 more minute, please. One more aspect. You use the expression that you have to prove that you have been practicing Islam for a period of 5 years. Now, are you going to tell me that Mr. Ahmadi, you don't offer prayers for 5 times a day?
That's it this way.
No, therefore there is an aspect of vagueness. How will you determine that? Will you tell a Muslim?
That's what I'm saying.
Will you prohibit him from dedicating a property?
That's what I'm saying.
Just 2 more points.
Stop me saying that.
Just, I'm not repeating anything.
I've heard you. I guess you the most important points you've already answered.
Just 5 more points. I won't repeat. I'm not repeating anything.
That's what I'm saying. I don't want to keep on repeating.
So I just highlight 2 or 3 provisions which have not been pointed out to my lords. My lord, the proviso to section 2, which says that any trust, even if the objects are similar to a Waqf, if it's established as a trust will be outside the purview of the Act, notwithstanding any judgment to the contrary. Lordship is asked to overruling the judgment in Chief Justice by Chawla. A judgment of the Supreme Court.
But they can always change the language of the statute because the trust also has certain benefits. You can't say that trust also has certain benefits. It's not that trust is deprived of all the benefits.
It's a question of regulation, lordship. And this is just an
What about the special law? Sections of the CPC apply.
Once a lordship section, again, lordship is, I'm not done. Just take a minute. Lordship section 104, which earlier allowed non-Muslims to also. So in the all of the lordship are breaking violation of 300A of the Constitution, which is right to property, saying that you can't alienate property, saying that you can't box property to exclusion of heirs. Lordship mentioned Hindu Succession Act, and Lordship Hindu Succession Act was a codification. It was not a question of imposing a law top-down contrary to personal laws. Here, saying that you can't box property
One submission in 10 seconds before your lordship call upon 1956, sir.
You know what happened?
One submission in 10 seconds before your lordship call upon the other side. Not just one submission in 10 seconds. Plus your lordship, insofar as correct, in 3 seasons concerned, is directly in violation of the principle in Roger Matthew and Madras Bar Association. Because it's directly in the teeth of those judgments.
Yes, Mr. Mehta.
One second, I just not, because
Mr. Mehta, now we want you to answer. I'll have 3-4 questions to ask you.
yes, but all your lordship's questions and the contentions will possibly not get answered in what I'm going to submit. But at the outset, 2 things. The lordships are dealing with a legislation, which has not just came as a legislation. But there was a constitution of a joint parliamentary committee. It held 38 sittings. It visited all major cities, held consultation from 13 July to 7 November 23. Examined 92.28 lakh memorandums, which are considered, and a bulky report is prepared. Thereafter, matter goes before both the houses of parliament and your lordships are aware. Detailed and elaborate debates are made. You kindly come to the act. Kindly have a look at some of the facts, provisions for a clause on the side place. I tell you to speak by inadvertence. But please have a look at the definition clause first. Please have a look at your lordships can take up my this chart. But it could be relevant because yes. But please have a look at Waqf by usual. One of the most contentious issue. Waqf by usual. But first of all, let me make one position very clear, and your lordships may kindly consider.
Are you now saying, Waqf by user, even if it has been established by judges for a particular case, or it is established otherwise, there is no dispute about Waqf by that now today stands void?
Therefore, I'm saying what was presented is not the correct statutory scheme. But first of all, Lord, and examine my arguments based on this. But I'll give two examples, Lord, not examples, Lord, in the case of Waqf. But I am a Hindu. I create a trust. My trust deed would say that all trustees would be Hindu. I would be, Lord, the settler of the trust. The trust deed would be the trust. And someone who will regulate the trust administrative secular activities would be the charity commissioner. Lord. Am I clear? It can be a public trust or a private trust. Here, in case of a Muslim, but Waqf necessarily under the Islamic law means dedication to Allah, Almighty Allah, for a particular charitable purpose is not accepted by the Islamic law. There has to be a Waqf. Waqf means the person who settles the trust. Is in parlance of Lord, which I example I gave, settler of the trust. There has to be Waqf. Waqf would say that it would be governed by a committee or an individual called Mutawalli, who all can be Muslims. Correct?
As far as work by user is concerned, right from.
Okay, I am not on work by user. But I have understood that. If a lordship can allow it, I
You only on work by user.
am. If a lordship is fine. So far as Waqf is concerned, if it is governed as per the Waqf or as per the Waqf deed or as per anything by Muslims, this law does not come into the picture. What is Waqf board? Waqf board is the charity commissioner for Waqf. First, Lord, please bear the distinction between Waqf board, Waqf council, and Waqf itself in mind. No act, Lord, this amendment touches the Waqf itself, and Waqf means the trust system.
Don't give the best example. Here's the example. In the Charitable Endowments Act, the Interreligious Charitable Endowments Act, the states have enacted that.
Under somebody's supervision.
How is that administered? They are pointing out provisions that whenever it comes to Hindu religious charitable endowment, the Hindu community which is administering it.
No. I don't wish to give examples. It will not be appropriate to give examples. I do not wish to, but they take it from me. Lord, Hindu religious endowments were not created by trust or by any other method. Lord, I am governed by the whatever method is, but ultimately, Lord, the statutory supervision, control, coordination is by a body which may consisting of Hindus, may not be consisting of Hindus. That is why 25 and 26. Let me.
Taking board doesn't have almost all Hindus.
Public trust takes note.
That's right. Trust is out. Trust is different. Trust is different because it's not. Because public trust, public trust,
there were several misstatements. No murmur from this thing. Let us maintain we are not arguing a religious thing.
No, but that's the
legal thing.
Mr. Mehta, in fact, Mr. Mehta does a.
Please come to the proviso.
Mr. Mehta, let us be clear. As far as religious endowments of Hindus is concerned, normally the Hindus are
No, that part. Can you come to the proviso? Can you come to the proviso at page 6 of my compilation, of my chart?
Yes.
Provided that the existing Waqf by user properties registered on or before the commencement of the Waqf Amendment Act 2025 as Waqf by user will remain as Waqf properties. If they are registered, it will remain. Somebody says that it did not register, and I'll come to that, Lord, what is the logic, and I'll satisfy your lordship. Except that I'll say that, Mr. Josefa, except that properties wholly or in part is in dispute. But there is a civil dispute going on between either a private party and Waqf.
Why will it not be remain about property? Let the civil court decide that dispute. Or if it's a government is raising a dispute, let it decide that. Now what is it?
Allow me to complete.
This is the second part of the argument.
The difficulty is when the petitioner starts without pointing out the contours, the respondent doesn't get to assess the court.
We have understood. We have the last part of it. First part we have.